This is an appeal in the matter of UK Innovations Group Ltd and AGA Rangemaster Group Ltd.
Yes, Mr. Manager.
Lord, Lady, I appear with Mr. St. Quinton concern for the appellant. My learned friend Mr. Salmi appears for the respondent and also a respondent's notice. The case is, I'll be doing this aspect of the case, the trademark aspect of the case. This aspect of the case is about exhaustion of trademark rights and the limited circumstances in which the law allows the proprietor to reassert such rights of goods which it has sold, in some cases, and in this case, many years earlier. The issue is comparatively rare before the courts, here and in Europe. And the reason for that is that exhaustion is the default position. It applies silently and comprehensively to the sales of all the goods bought and sold every day, and we think nothing of it. Only rarely does a trademark proprietor, having realised the profit by selling the goods, seek to reach into the aftermarket and pursue those who are repairing, reselling, modernising, or converting the goods that it has sold. Rarer still is the case where the court dismisses the complaint as lacking any foundation as regards the goods themselves, but somehow comes to the view that the marketing of the goods is objectionable. But this is such a case. Now, the appeal concerns the proper scope of Section 12.2 of the Trademarks Act and the conditions under which the trademark proprietor may rely on legitimate reasons to oppose further commercialisation of goods that have already been placed on the market with its consent and of which its rights are exhausted. The copy of the Section 12 that's in the bundles, I think, is the newer version, not the one that was in force at the time of the Act complained of. But I'll come to that in due course. Now, the case concerns AGA range cookers. For the uninitiated, these are not ordinary domestic appliances. Nominally, cookers with stovetops and ovens, they're traditionally left on continuously, radiating warmth throughout the house, or much of the house. Modern models can be switched off, but the products remain distinctive and very high priced. Models available from AGA, which is the OEM, only sells new models, range from about £5,000 for the very cheapest one, very small ones, more normally up to 15, 17, even £20,000 or more. Now, the cast iron body of these cookers makes them virtually indestructible, and they last an incredibly long time, sometimes in the decades. Quick switching rooms, probably won't put us with that. Find my place again. What that means, of course, is that because they last so long, there's a flourishing trade in these items. Second-hand trade, but also because they last so long with the more lesser lasting bits gradually deteriorating, they need to be refurbished or repaired. The other trajectory for these items is because they used to work off solid fuel, that is no longer popular, and many people wish to convert them either to gas or, more commonly, to electricity. Now, so far as the price of those items are concerned, they're also expensive. You will have seen probably in the papers, I hope, the approximate cost of these items is, again, £5,000 to £8,000. So we're talking about items that are extremely expensive, that they're a very considered purchase, and in respect of which the trademark rights have left or have been renounced or exhausted some time ago. So what I propose to do is to look briefly at the sort of policy of the law. That will involve a little bit of discussion of the cases, and then I'll turn to the main errors in the judgment, and that will also require me to look at some of the materials in the supplemental bundle and in the core bundle, so that one can see what goes on in the trade to the extent that that's available to us. So far as policy of exhaustion is concerned, it is there to crystallise what the proprietor has really, when it owns a trademark, what it actually owns, which is the right of first sale, which is realised, crystallised by the sale and results in an exhaustion of rights. And the function of exhaustion is fundamentally rooted in economic policy. It serves to balance the intellectual property's owner's interest in securing a just reward for the initial commercialisation of the goods against the public interest in maintaining free competition, free movement of goods within the marketplace. Now, in the context of European law, there's a distinction between the existence of an IP right and the exercise of the right. And the ECJ has clarified that the specific subject matter of a trademark right guarantees the owner the exclusive ability to use the mark for the purposes of putting products onto the market for the first time. And that right is the key right because it's intended to protect the owner from competitors who might illegally exploit the right. But because the specific subject matter is limited to guaranteeing commercial origin and quality associated with that, the principle of regional exhaustion has grown up, and in some territories international exhaustion. But the key point about exhaustion is the default position is that the right is gone. It can effectively revive under specific conditions, but, and I'll show you the law on this, legitimate reasons are a derogation from that basic position and need to be interpreted narrowly as a result. Now, I mentioned that the version of section 12 in the authorities bundle was the new version. The judge applied the old pre-amended version, so I don't think much turns on this. I just clarified this with my learned friend before the hearing. The tab 2. The amendment.
Tab 2 of what?
Oh, sorry, tab 2 of the joint authorities bundle. And it's page 13. So what is the first part has not changed. Does the old lady have that? A registered trademark is not infringed by the use of a trademark in relation to goods which have been put on the market in the United Kingdom, the European Economic Area, under that trademark by the proprietor or with his consent. So the default position is that's a defence to trademark infringement. And then section 2 disapplies that. Where's the best view of text?
The existing one,
Yeah.
19.
Page 111 of the core bundle, which is the judgment. Apologise, I thought we would have this morning. 1919. Yeah, that's the subsection as it stood. So subsection 1 does not apply where there exist legitimate reasons for the proprietor to those further dealings in the goods, in particular where the condition of the goods has been changed or impaired after they've been put on the market. Now, what's been added is a sort of proportionality and purpose language, which arguably was already there and probably has now been made explicit. But the key point for present purposes is that when it says in particular, where the condition of the goods has been changed, that has now been obviously expanded in the case law to include things like a damage to reputation, serious harm to reputation, or the creation of a commercial connection. Now, although exhaustion as an issue has arisen very commonly in the field of pharmaceutical repackaging, it applies, and pharmaceutical repackaging across European member state borders, it applies equally in a purely national context, and it is central to a flourishing secondary market, upcycling, recycling, part of the circular economy, and for trademarks, the third-party resale of branded second-hand goods lawfully placed on the market is obviously a large sector of the economy. Now, next topic is probably to understand what the judge decided in the case. The case was brought principally on the basis that the AGAs that were being sold by my client had been so cannibalized with so many new parts that effectively they were not AGAs anymore, and therefore the condition had been changed in a material way. That claim was dismissed. The second way it was put was that there was damage to the reputation, serious damage to reputation, through the poor quality of the components. That was also dismissed. But what was successful was the argument that the defendant's website and the way that it referred to the AGA ovens cookers on the website and the e-control system that it supplies was such as to fall foul of 12.2 and give legitimate reasons for the proprietor to essentially resuscitate its trademark rights. One other point I should say is that there was a claim, or at least an argument, for post-sale confusion that was initially found its way into the draft judgment but then came out. So the refurbishment and conversion works, that failed, the damage to reputation failed, and the post-sale confusion failed. There was also a joint liability claim against Mr. Michael Patrick McGinley, which also failed. Now there were, just for completeness, a number of counterclaims that failed and a number of defences that also failed. So before I turn to the judgment, I think it's probably useful to canter through some of the authorities. When I say canter, I'm not sure how fast I'm going to be. It depends how much pre-reading my laws and lady have actually done of the authorities. But there are some points that I think it's worth highlighting. So the first authority I wanted to show you, this is actually a case in which the fact that the authorities are in chronological order is extremely helpful, because you can see the accretion.
Which is always the right way to
Yes.
do an authorities bundle,
Yes.
precisely for that reason.
Exactly. You can see that in this case because there's more and more principles added and built upon the previous cases. That's not always the case. Sometimes it's a diagonal journey. But anyway, we start with Bristol Myers Squibb, which is a pharmaceutical repackaging case at tab 7 of your I'll be referring to paragraph numbers because I understand that there have been some pagination issues, and I myself have had pagination issues, so it's probably easiest to rely on the paragraph numbers. This is obviously a very influential case, particularly in the field of pharmaceutical repackaging, and it does have some statements of general application as well. And the first of those that I wanted to draw your attention to is at paragraph 48. And this is essentially the statement of principle which addresses both exhaustion and free movement. The right conferred upon the trademark owner to oppose any use of the trademark which is liable to impair the guarantee of origin, so understood, forms part of the specific subject matter of the trademark right, protection of which may justify derogation from the fundamental principle of the free movement of goods. And that really is sort of key point of principle. But then there are also a number of specific requirements or conditions that relate. It's actually not completely clear whether they are confined to the field of pharmaceutical repackaging. Some of them are more appropriate to that context than they are to other contexts, but some of them may be of broader application. I know my learned friend relies on one or two of them, but I don't think there's anything particularly complicated about them. Anyway, I'll show you what I mean. Paragraph 70 and they say it's in the trademark owner's interest that the consumer or end user should not be led to believe that the owner is responsible for the repackaging, and as such an indication must be given on the packaging of who repackaged the product. As the court has already stated, that indication must be clearly shown on the external packaging, and that implies that the National Court must assess whether it's printed in such a way as to be understood by a person with normal eyesight. It is, however, not necessary to require the further express statement be made that the repackaging was carried out without the authorization of the trademark owner, because that effectively suggests that the repackaging is somehow illegitimate. And then over the paragraph 73, where the parallel importer has added to the packaging an extra article from a source other than the trademark owner, he must ensure that the origin of the extra article is indicated in such a way as to dispel any impression that the trademark owner is responsible for it. And similarly, next paragraph, a clear indication may be required on the external packaging as to who manufactured the product, since it may indeed be in the manufacturer's interest. The consumer or end user should not be led to believe that the importer is the manufacturer of the trademark. Now, I would suggest that those requirements actually find their way through all of the cases. Identity, or identifying who has done what, is important. The trademark of the seller, or the name of the seller, must be clear in a exhaustion case, and equally I'll show you cases which make it clear that you have to make it that the identity of the manufacturer of the goods, the original manufacturer, the person who put them on the market, must also be shown. And I think that's true of all of these cases. So far as the requirement at 78 is concerned, which is about giving advance notice of the repackaged product being put on sale, I'm going to suggest that's not of wider application, or at least it doesn't find its way in any of the cases as being a requirement outside the pharmaceutical sphere, so far as I'm aware. So that's the case. There's some important principles there, but also some nitty-gritty in terms of the requirements. that is the next case I wanted to take you to was Parfum Christian Dior, which is tab 8. And this is an important case because it revolved around the way the goods are marketed. Dior operated an exclusive distribution network. The defendant was not in it, but obtained a quantity of products by parallel importation legally. Dior complained some of the Christmas sale leaflets, which, although not up to the usual Dior standards, were fairly typical of Christmas leafleting and marketing by traders, other traders. Now, this case is significant because it shows that one has to be quite careful impugning advertising, because otherwise you are left with a quantity of goods that you really can't tell your customers about. So if you look at paragraph 20, which will be the first paragraph I return to. Sorry, that's a bad reference. Apologise for that. Page. So I'll just translate that. That's right, it starts with the AG's opinion. Paragraph 31 of the Advocate General Jacob's opinion. 31. If a reseller is free to sell products placed on the market by the trademark owner or with his consent, it must follow that he's free, in principle, to advertise the goods also. A reseller's right to market products would be rendered virtually meaningless if the trademark owner were always entitled to prohibit him from advertising the goods. That's particularly so if one considers advertising includes point of sale material and arguably even displays of the product. If the principle of the exclusion of rights never extended to advertising, resellers who lacked the trademark owner's consent to advertising would be obliged to keep all sign of the products concerned under the counter in the hope that customers requested it. So that point is followed through into the judgment as well. And it is said that if you pick up the judgment at 42, so this is talking about, it's coming out of the passage talking about the advertising function of a trademark. And 40 picks up the counter-argument on legitimate reasons. So the exhaustion of rights rule is not applicable where there are legitimate reasons for the proprietor to oppose further commercialisation of trademark goods, especially where the condition of the goods is changed or impaired. And then the question, therefore, is whether the situations constitute legitimate reasons allowing the proprietor to oppose use of the mark by a reseller to bring the public's attention to further commercialisation of the goods. And the development in this case, first of all, they note that the word especially in the directive means that it's a non-exhaustive list of things that can happen that would result in legitimate reasons. But it is said that it's intended to reconcile the fundamental interest in the protection of a trademark rights with the fundamental interest in the free movement of goods. And then the key paragraph is the following: the damage done to the reputation of a trademark may in principle be a legitimate reason allowing the proprietor to oppose further commercialisation of goods which have been put on the market by him or with his consent. According to the case law of the court concerning the repackaging of trademark goods, the owner of a trademark has a legitimate interest in being able to oppose the commercialisation of the goods. 45, they note that these are prestigious luxury goods, and which obviously result in a need to prevent advertising from affecting the value of the trademark, from detracting from its allure and prestigious image. But there's an important caveat, which is the fact that a reseller who habitually markets articles of the same kind, but not necessarily of the same quality, uses for trademark goods the modes of advertising which are customary in his trade sector, even if they're not the same as those used by the trademark owner himself, by his approved retailers, does not constitute a legitimate reason in the meaning of Article 7.2, allowing the owner to oppose advertising. And then, unless it is established that given the specific circumstances of the case, the use of the trademark in the reseller's advertising seriously damages the reputation of the trademark.
To what extent is this relevant to our case? Because this is all about damage to the reputation of the trademark. And as you said earlier, that wasn't the basis of the judge's decision that you're appealing.
The significance of this is that the mitigating factor for the check and balance is whether it's trade practice. And this is the first case that brings that into view. So
you're relying on the reference to customary in the trade sector,
yes.
are you?
And it's even if they're not of the same standard of the trademark proprietor. So there is one other point, which is it's significant, we say, that the Court of Justice adopts serious damage. And we say, looking at the soon-to-be 3 types of harm that exist under legitimate reasons, so far I've got altering the condition of the goods, impairing the quality. You've got serious harm to the reputation, serious damage to the reputation, and you've got shortly the creation of a commercial connection such that the consumer considers there to be a connection. I'll suggest that it is strong stuff that's required in order to trigger legitimate reasons. It's serious, serious effects. The next case is BMW Denick, and this is a case that extends the principle further. Now, BMW operates a network of authorised dealers in Benelux countries. Mr. Denick ran a garage business. He sold second-hand BMWs and repaired and serviced BMW cars. There were various findings below, whether he could say repairs and maintenance of BMWs or specialist in BMWs, or just use the mark BMW. And obviously this raised a question about the ability of people to provide services and also sell goods. There were 2 separate questions. There was the sale of second-hand goods in which the rights had been exhausted, and there was the supply of repair services. The other point about this, and it's just a point to keep an eye on, is the particular form of commercial connection in this case was about whether he would be seen as part of the distribution network or authorised dealer network or not, as opposed to whether he was BMW as such. But that may be a distinction without a difference, but it's something that it's a feature of all of these cases where they're talking about commercial connection. We can see from 31 what the referred question was. But second and third questions, which should be considered together, National Court is in substance asking whether the use of a trademark without the proprietor's authorisation in order to inform the public that another undertaking carries out repairs and maintenance of goods, or that it's specialised, or is a specialist in such goods, constitutes a use of that mark. There's an interesting, but for today's purposes, not relevant debate about whether the mark is being used in relation to relevant goods or services. And we can skip over that and go to the 39. The advertiser uses the BMW mark to identify the source of the goods in respect of which the services are supplied, and thus to distinguish those goods. If the use of the trademark in advertisements for services which consist of selling second-hand BMW cars is undoubtedly intended to distinguish the subject of the services, it's not necessary to treat any differently. So that's how they concluded that particular, or resolved that particular debate. Now 44 is where it starts to deal with the exhaustion issues. The court is asked to rule on the question whether the trademark proprietor may prevent such use only where the advertiser creates the impression that his undertaking is affiliated to the trademark proprietor's distribution network, or whether he may prevent such use where, because of the, this is quite a difficult concept to understand, I'm going to try and where, because of the manner in which the trademark is used in the advertisements, there is a good chance that the public might be given the impression that the advertiser is using the trademark in that regard, to an appreciable extent, for the purposes of advertising his own business as such, by creating a specific suggestion of quality. I think what's being said there is, the first part is he communicating that he's part of the dealer network? The second one is, even if he's not doing that, is he using the sign gratuitously to enhance the image or quality of his goods or services? And is there anything wrong with that? And then the court splits the questions into two separate parts. The advertisements for the sale of second-hand BMW cars starts at 47. They cite Dior and note that that could be a legitimate reason as regards prestige goods. But as Justice Arnold a moment ago, strictly speaking, that is not the issue in this case being BMW. And they say that in the context of the present case, the consequence of that decision is that it's contrary to Article 7 of the directive for the proprietor of the BMW mark to prohibit the use of this mark by another person for the purposes of informing the public that he has specialised or is a specialist in the sale of second-hand BMW cars, provided that the advertising concerns cars which have been put on the community market by the proprietor with his consent, so in respect of which the rights are exhausted. As regards this enhancement, I know that's coming up, sorry. 51, they say that if it's used in a way which it may give the impression that there is a commercial connection between the reseller and the trademark proprietor, in, for example, affiliation, or part of being the network, or that there's a special relationship between the two undertakings, that may constitute a legitimate reason. That advertising is not essential to the further commercialisation of the goods. In other words, it doesn't fall within the purview of things that the law protects as part of exhaustion. And then they go on to say, if there's no risk that the public will be led to believe that there's a commercial connection, the mere fact that the reseller derives an advantage, the enhancement argument, does not constitute a legitimate reason. So there's nothing wrong with getting an enhancement as a bonus, so to speak, if the statements and advertising are protected as part of the right of resale. And they note that it's sufficient to state that a reseller who sells second-hand BMWs and who genuinely has specialised or is a specialist in the sale of those vehicles cannot in practice communicate such information to his customers without using the BMW mark. And as a consequence, such an informative use of the BMW mark is necessary to guarantee the right of resale. I want to fasten on those words, informative use, because there's been a certain amount of terminology debate in this case, whether it's descriptive use or nominative use, I think they call it in the States, or fair use. My submission, that is an accurate way of describing the use by the reseller of the trademark proprietor. It's informative use, it's required to be there, and it may have certain advantages as well, but it's informative because it's giving accurate information in relation to the goods, in respect of which trademark rights are exhausted.
And then they say in paragraph 55, whether advertising may create the impression has occurred at commercial connection is a question of fact for the National Court.
Yes, that formula is the last time they say that, because what I'm going to show you in the subsequent cases is they say that, but they say nonetheless we consider that we need to provide guidance on this particular issue.
Well, can I be clear as to where you're going? Are you disputing that it's a question of fact for the National Court?
No, I'm not. But as is the way with ECJ references, they can provide guidance that will assist the National Court in applying what may be an elusive principle. This is not written down in the directive or act, and therefore we've only got case law to go on, and for that reason I think they feel that they need to elucidate matters a bit. The next case is the porter cabin case. This case had a bit of complexity to it, but we don't need to worry too much about the far reaches of it. It was one of the early internet AdWord bidding cases that went to the ECJ, and it's obviously a very significant case generally, but for present purposes, the only relevant points are that porter cabin, beloved of Private Eye and other publications, sought to enforce their trademarks against Prima Cabin, who were selling second-hand mobile buildings, including units manufactured by Porter Cabin. And what they did was they removed, debranded it was called, the Porter Cabin mark from the I hesitate to say Porter Cabins, from the mobile buildings. And as part of that, they also bid upon the trademark Porter Cabin as a keyword to trigger advertising if somebody did a search. Their ads would come up. They also bid upon misspellings, Porto Cabin, Porter Cabin, and so on, with a C and with a K and so on. And so the question was, how does, and this was at the time not clearly established, not until Google France, not known to be trademark infringement at all, not known to be use of a sign, not clear whether it was in the course of trade by the relevant party in relation to the relevant goods. Google France is in the bundle. I wasn't going to go into that. That was resolved by Google France effectively. It is a special case because the sign is often not visible in the ad. It is arguably Google that are administering the use of the sign. It's the advertiser who is selecting the sign and causing it effectively to trigger advertising for that advertiser's goods, and therefore its use in relation to those goods. But because of the rather unconventional configuration of liability in those cases, the Court of Justice came up with what may be regarded probably with hindsight as a sui generis test, which is transparency test, difficulty in telling test. It doesn't require positive finding of confusion, but if one thinks about it, in a double identity case, identical mark, identical goods, normally you don't have to show anything other than there's been use without consent. It's an effect on the functions, but you don't have to show anything more. But because of the specifics of that type of liability, the Google France court came up with this formula, which is, can the ordinary internet user tell, or tell only with difficulty, whether the advertising emanates from the trademark proprietor or not? And I'll return to that when I come to the judgment, because they applied that in Porter Cabin. You can see that from paragraph 80 and 81. But that was in relation to the keyword advertising. So if I could pick it up from, yes, 80 of the Porter Cabin judgment. The fact that a reseller, through its advertising based on a sign identical with or similar to the trademark, gives the impression that there's a commercial connection between the reseller and the trademark proprietor, and in particular that the reseller's business is affiliated to the proprietor's distribution network, or that there's a special relationship. Although that formula so far we're familiar with, because that comes straight out of BMW. That constitutes a legitimate reason to, within the meaning of Article 7.2, advertising which is liable to give such an impression is not essential to the further commercialisation of goods based on the market under the trademark. So we obviously had an identical sign for identical goods, or almost identical in relation to the typo keywords. So how could they resolve it? Well, they resolved it in paragraph 81 by saying that it follows that in the circumstances referred to in paragraph 54 above, in which a trademark proprietor is entitled to prohibit use, 5.1 being the double identity or similarity, the use by the advertiser must not enable normally informed and reasonably attentive internet users, or enable them only with difficulty, to ascertain whether the goods or services referred to by the ad originate from the proprietor of the mark or from an undertaking economically linked to it, or on the contrary originate from a third party. And then that's a very long sentence. That corresponds to a situation in which Article 7.2 of that directive applies, and in which accordingly the advertiser cannot rely on the exhaustion rule laid down in Article 7.1. But critically, this was in relation to the advertisements of goods in which the Porter Cabin mark had been debranded. So obviously, if they were selling genuine but exhausted Porter Cabin mobile buildings with the Porter Cabin trademark on them, there wouldn't be an objection. Because
Sorry, can you explain that to me? Because this is at the stage of the keyword advertisement. That is to say, long before the consumer has seen the goods that they're going to order, assuming they do place an order at all.
it is
So what's the relevance of the debranding in that context? Because the consumer doesn't know whether they're branded or debranded.
if, as a matter of fact, they were, for example, a Porter Cabin distributor selling genuine, new Porter Cabin mobile buildings, then the consumer would rightly expect that comes from the proprietor. But if, as a matter of fact, they're not, and they're selling, let's say, counterfeits or anything else, debranded goods, that makes the Google France test, satisfied at the stage that the consumer does the search. It is artificial. I'm not suggesting that it's necessarily intellectually satisfactory, but that is the approach they took. If it were otherwise, they would simply have been banning the advertising for no reason. Or they would have been impugning the advertising for no reason. This was specifically linked to Article 7.2 of the directive. And the advertiser can't rely on exhaustion.
I'm sorry, I'm struggling because as I understand it at the moment, and one can see this, for example, from paragraph 82, this is all about the advertising. It's got nothing to do with what's on the goods.
Well,
First of all, Mr. Manager, have we missed something? Does it mention what's on the goods in that paragraph? I mean, it's a rhetorical. I don't think it does. I don't want to.
not in the paragraph we were just looking at, but I think it does in the intervening paragraphs. I've probably gone.
Well, there's no doubt. I'm not doubting there was debranding, because they were also selling some goods that weren't porter cabins.
Yes, exactly so. That's right.
That's all true, but that's not the point. The question is, which my lord's question is the same one I'm asking you: is why does that have something to do with what's being said in paragraph 81, which is what you're saying?
Because if they were not so the advertisement did not allow the consumer to tell without difficulty whether the goods came from porter cabin or not.
No. Look at paragraph 82. To ascertain whether prima cabin is a third party vis-a-vis porter cabin, or on the contrary, is economically linked to it.
Exactly.
So it's about the connections between the companies,
Yes.
not about the goods.
But if as I read this, my lord, and maybe I have it wrong, but as I read this, if they were selling, as they were, selling porter cabin mobile buildings with porter cabin on them, where the rights were exhausted, there wouldn't have been a problem. Because
On the contrary, what the court is saying is there is a problem if the advertising suggests a connection which is wrong.
And that's right. I mean, that's just like BMW. You can be selling genuine, I'm going to call them genuine goods. Now,
Yeah.
you can be selling genuine goods, but you can still be selling them in the wrong way,
yes,
even if you're selling
I
genuine
can
goods.
see that. I can see that. I can see that interpretation. I don't think that matters for the purposes of my appeal, because in any event, it's a keyword test. It's a keyword advertising test, and it's sui generis. It's not of general application.
Okay, so when in 81 it talks about corresponding to a situation in which Article 7.2 applies,
Yeah.
you say, as I understand it, oh well, you have to read that only in the context of keyword advertising, rather than saying that what comes before generally corresponds to a situation in which Article 7.2 applies. Have I understood that?
I think that is my submission. Yeah. It can't be. I mean, against my lord's interpretation is why they're even discussing Article 7.2 at all, if it's not relevant to the exhaustion and legitimate reasons to oppose. So, but
Sorry,
I can see that.
just for my benefit.
Yes. It's
Article 7 doesn't otherwise come in
no.
to the analysis.
Article 7 is section
Because
12.
we're talking about advertising, we're not
Exactly.
in terms talking about exhaustion. Is
So
that-
imagine there was no exhaustion, then you would be talking about Article 5, and you'd be saying, under Article 5, there's an infringement of trademark, and the keyword test applies in relation to that. It's the fact that they talk about Article 7, and the only relevance of that here is because of porter cabins' exhausted goods.
Well,
as I-
to be clear, there was a referred question which was all about Article 7. It was
Yes.
the third question,
Yes.
which is what they're considering. And as they explain in 75, the whole reason why the question was asked is that the advertising referred used keywords identical with or similar to porter cabin's trademark, and it concerned to a large degree the resale of used mobile buildings originally manufactured by porter cabin, common ground goods placed on the market in the EA by porter cabin under the trademark porter cabin. So hence the issue, and they go through BMW and Dior and Evora, and that's the test that they are then applying in 81.
And Mr. Marlich, as I understand 81, what it says, if you look at the beginning, it says it follows that the circumstances referred to in 54 above, you see that? 54.
Yes.
What 54 is about is keyword advertising. So what 81 is talking about is a keyword advertising situation.
Yes,
And then what
exactly.
they do in 81 is they import the test, the Evora test, I'm going to call it that, into the section, the Article 7.2 situation. But so far, none of this has got anything to do with whether the
Yes.
porter cabins were branded or not branded.
Right. Yes. I mean, I can see that. I think it's far from clear, but I can see that. I think for my purposes, the only reason to stop at this case and consider it is because on any view, that test can't be transplanted to a different fact pattern. I mean, it can be transplanted to a different fact pattern involving internet searches and the features of internet search. Some of those features are the consumer has entered, it's been established and acknowledged by the court that when a consumer enters a trademark search term, in general he or she is looking for goods bearing that mark. Secondly, that the mark may remain exposed on the above the list of search results. That's a use that's not necessarily attributable to the advertiser. And of course, there's the fact that it may not appear in the ad, it may appear in the ad. So the reason for this very specific test, and it is very much my submission of application only in this context, or very similar context. It might be that it's applicable to some other kind of interactive internet activity. One has not seen it given wide application, and here it is being applied in the classic fact pattern, which is search on Google. Beyond that, the case repeats some of the principles that we've already seen. So 89, the mere fact that a reseller derives an advantage from using another person's trademark, which are in other respects honest and fair, lend an order of quality, does not constitute a legitimate reason. Because you'll have difficulty communicating the sale of your goods at BMW. And just to be clear, just on the scope of that test, in the 92, in the light of all the foregoing, the reply to the third question is that the Article 7 of the directive must be interpreted as meaning that a trademark proprietor is not entitled to prohibit an advertiser from advertising on the basis of a sign identical with or similar to that trademark, which that advertiser chose as a keyword for an internet referencing service without the consent of the proprietor, the resale of goods manufactured and placed on the market in the EEA by that proprietor or with his consent, unless there's a legitimate reason which justifies him opposing the advertising. So I think they, one way or another, they are. It is quite a specific test. The only other point is 93. Legitimate reasons may also be. Is obliged to find that there is such a legitimate reason to use a second indent without the consent of the proprietor, which it uses in the context of advertising for its resale activities, has removed reference to that trademark from the goods manufactured and placed on the market by that proprietor and replaced it with a label bearing the reseller's name. And that's what was distracting me in thinking that those two things were linked. That they may not. It doesn't matter. Then we come to the last two cases, and these are probably the most important because they represent the sort of most up-to-date position without huge development, but more detail given and more guidance given. The first of them, they're both involving gas cylinders of very different sizes. One was gas bottles covered by a three-dimensional mark, Viking gas. And this seems to be the sort of Cala gas situation, where a user will buy a cylinder full of gas, use the gas, take it back, pay less for the next cylinder full of gas because they traded in the previous one, and they can get them from a large number of traders, and there's a flourishing trade, effectively used bottles. Because of course when the bottle is sold, it belongs to the consumer.
Well, it depends on the business model. I mean, that said, Cala is a distraction because under Cala's business model, they retain title to the cylinder.
They say they do they? I'm not sure. Yeah.
Well, there is. I mean, it may have changed more recently, but certainly back in the day there was case law to support that.
Support that, right, right. Yeah, so I think here they acknowledge that it's the consumer's property. And the question is all about the branding on the gas bottle. And it's complicated by the fact that the bottle itself is protected by a three-dimensional trademark. The claimant was Kosan Gas, Viking was the defendant, and they were competitors as well in the supply of these filled gas canisters. And probably best to look at the third questions, which you can find 14. Company B guilty of an infringement of a trademark fills gas which originate from Company A where the following circumstances apply. Composite bottles with a special shape, which is registered as a trademark. On first purchase of a composite bottle with gas from one of Company A's dealers, the consumer also pays for the bottle, which thus becomes the consumer's property. Company A fills the composite bottles by a procedure under which the consumer goes to one of his dealers and can exchange it. But Company B, Viking, their business consists in filling gas into bottles, including composite bottles covered by the shape trademark, and on payment for the gas, can have an empty composite bottle exchanged for a similar one filled. There are adhesive labels attached to the bottles. When they're filled with gas by Company B, adhesive labels stating its name, stating that the bottles were filled by Company B, is placed on the labelling. And consumers may generally receive the impression that there's an association between Companies A and B. Is this to be regarded as significant for the purpose of answering question 1? Question 1 is answered with a negative. May the outcome be different if the composite bottles also feature the registered figurative and word mark of Company A, which is still visible, irrespective of any adhesive labels. So we've got a number of questions relating to the presence or absence of prominence of the original maker of the bottle and owner of that trademark versus the filler. So I think we can go to the findings of the report. And the first point is that is probably the point made in 31. In those circumstances, balance must be struck between, on the one hand, the legitimate interest on the part of the licensee of the right to the trademark in profiting from the rights attached to those marks, and on the other, the legitimate interest of purchasers, in particular the interest in fully enjoying their property rights in those bottles, and the general interest in maintaining undistorted competition. So those interests have to be given full weight. Now, the first of those interests, of course, is part of exhaustion itself. They've made their money on the sale. So that has already been satisfied. That's not to say they don't have other interests, interest against confusion and interest against harm to their reputation, but they do have some money in the bank, so to speak. Now, so far as the purchaser is concerned, what it does, actually what the court does after that, is they go through and provide a bit of detail on those interests. 32, they talk about the realised interest in the first sale. 33, as regards the interest of purchasers, it's common ground they may not fully enjoy their property rights if those rights are restricted even after the sale. Because purchasers would no longer be free to exercise those property rights, would be tied to a single gas supplier for the subsequent refilling. And then there's an effect on competition identified in 34. The licensee or the proprietor could reduce competition on the downstream market for the refilling of gas bottles, and would even create the risk of that market's being closed off if the licensee and proprietor were to succeed in imposing its bottle because of the specific technical characteristics, the protection of which is not the purpose of trademark law. The risk is moreover increased by virtue of the fact that the cost of the composite bottle is much more than the gas, and that the purchaser, in order to regain a free choice of gas supplier, would have to forego the initial outlay made in purchasing the bottle. 35 is a bit more about the purchaser and the right to choose the gas supplier of choice. And the corollary of that right on the part of the purchaser is the right of those competitors to refill and exchange empty bottles. Now, as regards the limits on those rights, they say it must be borne in mind that pursuant to Article 7.2, the proprietor of a mark may, despite putting on the market of goods bearing his mark, oppose further commercialisation where there are legitimate reasons. And according to settled case law, they mention this point about especially not being exhaustive, and then they cite the fact that there's been already case law on damage to reputation, or giving the impression that there is a commercial connection between the trademark proprietor and the third party. And this is, I think, an answer to my Lord's question earlier, 38. Although it's the task of the National Court to assess whether, having regard to the circumstances of the case, such a legitimate reason exists, it's however necessary to provide that court some guidance in respect of that assessment, in particular as regards the specific matters on which it seeks a ruling. Not sure how relevant that's got to do with the reference procedure, but anyway. But the factors that they say are important, we say are of general application. First of them is 39. And that is, it's necessary to take into account the labelling of those bottles and the circumstances in which they are exchanged. It is a global test, a holistic test. You don't simply look at one aspect. You look at the transaction, let's say the whole transaction, in order to assess whether there's a giving the impression of a commercial connection. And this is, I think, perhaps comes out of the answer I gave a moment ago about seriousness. This has to be a well-established and serious commercial connection. The labelling of the composite...
Sorry, I don't understand that. When we look at 37,
yes,
the adverb seriously applies to damaging the reputation of the trademark.
Yes.
When it comes to commercial connection, there's no use of the word serious or seriously.
What I have in mind, my Lord, is this. If you look at 39, it must be stated in order to answer the question whether the commercialisation of the composite bottles refilled is carried out in such a way as to give the impression that there is a commercial connection between the undertaking. There's no use of the word likelihood or risk, and it says commercialisation. It's the holistic approach that is being taken. So you look at it in the round and ask whether there is a commercial connection between that undertaking and coast gas. Now we know
It's not there is a connection, it's there's an impression.
there's an impression of, there is an impression. Well, it says such a way to give the impression that there is a commercial connection between that undertaking and coast gas.
So is it your submission that a likelihood is insufficient?
I don't say that you have to have established already the behaviour or the effect, because otherwise you wouldn't be able to get, let's say, an injunction if it hadn't happened the word likelihood denotes a degree of probability that may be inappropriate in this context. The courts don't use that language. And therefore, we would say that it must be properly substantiated. If there is a risk, it must be a properly substantiated risk. It isn't a matter of simple assessment by the court. It should be the subject of evidence. It should be the subject of substantiation in whatever.
So you say it's not a matter for assessment by the court. I don't follow that.
Well,
Can you explain what you mean by that?
The question of whether two trademarks are confusingly similar is notoriously a jury question for the judge. And the judge is in the same position as any consumer for ordinary goods and services.
Right, so and you're saying this is any different?
I say this is different. And the reason why this is different is because one is required to look at trade practice, one is required to look empirically at what is happening and find that that impression is being established. Again, I don't want to set the bar too high. For example, there may be no evidence of that. There may be no consumers who have reported that that has happened. But it must be, it's a bit like, I would suggest, acquired distinctiveness, in that acquired distinctiveness generally requires more than simply a hunch that the mark has been around for a while. It requires the court to consider evidence having a bearing on the issue.
So, to be clear, you're not submitting that the claim fails unless there is positive evidence of consumer deception?
No,
Right.
because there may be reasons why that hasn't come to light,
Okay.
apart from anything else.
So, I'm left therefore scratching my head as to how this differs from a likelihood of confusion test.
Because a likelihood of confusion test can be purely prospective, can be purely based upon, and the judge.
But you accepted that this could be purely prospective because you accepted that it might be a queer tenant claim for an injunction.
Yes. The difference is that in a case such as this, there is already, there will be evidence of market practice, and there will be evidence having a bearing on whether there will be a genuine and properly substantiated impression of a commercial connection. Because, if I can put it this way, it isn't appropriate, we say, for the court simply to stand in the shoes of the average consumer in a case such as this, because it is so context dependent. So, if one takes...
I'm sorry to keep interrupting you, but you keep on making statements which I find puzzling, and therefore I need to elucidate. You say the court shouldn't stand in the shoes of the average consumer. That's quite a radical submission, because in most issues in trademark law, that's precisely what the court is required to do. So why does the court not stand in the shoes of the average consumer?
If one, because the question is not simply a question of human perception. The question is one of context, information about what other traders are doing and what is likely to happen. So, as I say, it's a bit like...
But it is human perception. Impression is nothing else. Is it not?
Well, they say...
I can see you're making a point about the things that you need to take into account to try and determine.
Ultimately, that could be this. Yes, it could amount to the same thing as long as you take those things into account. It could amount to the same thing. But the difference is that in a pure likelihood of confusion case, you don't need any evidence of anything. You just look at the sign and the mark. You don't have to have evidence in order to compare them visually or
the jurisprudence of the Court of Justice is very clear that likelihood of confusion requires a global assessment taking into account all the relevant circumstances. Why is this any different? Because it seems to me at the moment that all your submission amounts to is that the court must take into account all the relevant circumstances, which would include things like trade practice and labour.
Yes, but also upstream and downstream. I'm going to come to that in the next case, because it's not just a law of signs here. It's an assessment of the trajectory of activity. So it's a number of different players, a number of different signs. If one thinks about it this way, you may infringe section 12.2 without using the trademark at all. It might just be because of the nature of your statements to the trade. I am an affiliate of I'm an authorised dealer, you may say, and you're not. So you're
There has to
passing
be
on.
use of the sign. I mean, let's leave aside Mitsubishi, which is controversial.
Yes, exactly.
But leaving that case aside, and it's the specific circumstances of that case, the ordinary law is, in order to infringe a trademark, you need to use the sign in question. If you don't use the sign in question, you can't infringe the trademark.
You may be doing something else wrong, but you're not infringing the trademark.
Absolutely, no, I misspoke. What I meant was that you don't have to use the trademark in the statement that's causing the connection to be made. Right? So you're putting the mark on the goods, and you're using the trademark, but you want to rely on section 12, but you're also putting out statements saying I'm an authorised dealer. Nothing trademark infringing about that, but that does give legitimate reasons to...
Yeah, it's the two together, is your
The
point.
two together, I suppose.
Yeah.
But I mean, that's not the strongest rationale. I mean, it's really just a question of, because it's so temporally, locationally, and in terms of the players or the relevant entities involved, complicated, we would say it isn't a sort of thing one can decide on a hunch. It's got to be done in a more structured way. There's a degree of conviction about it.
So, but the impression is clearly one that applied to the facts of this case, what the consumer might see if they go to the website. It must be the impression on them.
It is the consumer.
You can't surely invest them with all the knowledge of the market that you're talking about.
Well, I mean, as I say, it's a bit like
Not
acquired...
necessarily.
Not necessarily, but it's a bit like acquired distinctiveness. Ultimately, the question is adopted from the vantage point of the average consumer, but it's a whole lot of market evidence that might be put forward, from surveys to sales figures, publicity spend and so on, that then leads the court to say, well, from the average consumer's view, the word budget does mean rental cars. And so it can acquire that distinctiveness. I mean, it may not matter, because ultimately what really does matter is that as long as you're taking very much a 360 view over time of all of the ways in which the commercialisation is taking place, then ultimately, if at the end of that process you're adopting a consumer-centric, average consumer point of view, it may not matter. But I think I was trying to make a point about the degree of conviction that one has to have in the finding. That maybe I'm pushing too far on this case. It might be better.
I don't understand what you mean by that. I mean, the judge has to make a finding of, and the finding is a finding of fact, and the facts are decided on the balance of probabilities.
Strictly speaking, that's right. Yes.
Well, not just strictly speaking. It's right, isn't it?
Yes, but it's what has to be established. If I could readdress you on this in the next case, because I think maybe the next case might be maybe more suitable. So, I mean, here of course, they also re-emphasise that it's necessary to take into account the practices of the sector, and in particular whether consumers are accustomed to the gas bottles being filled by other dealers. I mean, this, you will know from the debate over surveys that it's very difficult to do a survey now in the field of likelihood of confusion, because the judge is well placed to make that assessment. But you may be able to do a survey in the field of acquired distinctiveness, because it's about what has happened, or it's more empirical in nature. And that is a bit the case here, which is...
Isn't there a difference though? Because in a refilling packaging case, such as one of our gas bottles, the individual consumer in question may well be someone who refills gas bottles relatively often.
Yes.
And so there's a logic, there's a meaningfulness about the consumers being accustomed to doing something with gas bottles. at least bearing in mind the way you opened this case, I don't suppose there are all that many consumers who are accustomed to buying Argas, plural.
Well, maybe some, but not too many. I think they tend to be lifetime.
The average consumer is not going around buying an Arga every week.
No. They might have a chance of getting a recondition.
But it's not part of your case that we're talking about repeat buyers of Argas.
No, I mean, but my lord, if my lord is suggesting that one route to the finding is to say, look at your average consumer and the attributes of that average consumer, then I agree, because I think that's all you're doing by the process that I'm trying to describe really poorly, which is that you've got, the court would need to clothe itself with all of these attributes, and it may not be a buyer of gas bottles, and therefore not know whether consumers are accustomed to getting gas bottles being filled by the dealers. But if the route to getting there is to inform itself about the nature of the average consumer and their knowledge, then that's sufficient. I think that's probably all on that one. And then the last one is the SodaStream case, and that's a post-Brexit judgment. It's behind tab 16. This concerned gas cylinders used for making beverages, gas carbonated beverages, I think, in Finland. And the court was quite strident about some of the points and a bit more forceful than the previous courts. So I mentioned that I would take you to an authority that makes it clear that Section 12 is a derogation from, Section 12.2 is a derogation from Section 12.1. And you can find that in paragraph 34. Other cases have said that, but this is just one of the more recent ones. The proprietor of a trademark may provide evidence of legitimate reasons to oppose commercialisation, especially where the condition of the goods is changed or impaired. That ability to oppose, which amounts to a derogation from the fundamental principle of the free movement of goods, has the sole objective of safeguarding rights which form part of the specific subject matter of the mark as understood in the light of its essential function. So it's got to be, that's got to be impugned. And 37, they recite the Advocate General's opinion, point 22, insofar as it necessarily amounts to a limitation on the fundamental principle of the free movement of goods. The right of the trademark proprietor to oppose further commercialisation of the goods bearing his or her trademark is not unlimited. That formula of words is quite common in European judgments, where it indicates that can't be pushed too far. So a lot of the same considerations applied. The facts were slightly different in this case, in that the defendant actually removed the claimant's mark from the labelling, replacing it with its own mark, but the claimant's mark was engraved on the bottom. So it was, at least, it had some presence, but it had been downgraded. So that was that's the sort of fact of it. But they say at 42 that in the context of parallel imports of repackaged pharmaceutical products, the court has drawn up a list of conditions in order to frame the existence of such reasons in that specific context. And then they say, in a context closer to that issue in the main proceedings, the court has held that it's a legitimate reason, and they mention porter cabin and Viking gas. And they say, it follows that a false impression which may arise in the minds of consumers as to whether there's an economic connection between the trademark proprietor and a reseller is one of the legitimate reasons for which the trademark proprietor may propose further commercialisation. They talk about where the original mark, they remove the original mark, fix their own label. But they say, they talk about a false impression. I mean, that's not a likelihood of confusion. That's a false impression. Now, there might be a subtle difference, but confusion can include considering that they're linked, but not necessarily that you have a false impression. I mean, it's maybe just language, but it strikes me as being something that is intended to be at least something more, something harder.
If you have an impression of something, if you have an impression of something which is false, why is that not a false impression?
That is a false impression.
But isn't an impression of something which is false exactly what the cases up till now were talking about? An impression of a connection in trade between
Yes,
the two companies.
it does. It does. It hasn't changed. It hasn't changed, but they say in order to assess whether such a false impression exists, account must be taken of all the circumstances relating to the reseller's activity, such as the way in which the cylinders are presented to consumers following the new labelling, and the conditions under which they are sold. In particular,
So, as I suggested to you earlier, question fact taking into account all the relevant circumstances, yes?
yes, if you're prepared to draw context a lot wider than you are trademark infringement. Although now it takes account of post-sale confusion, it might be said to be getting broader. We haven't gone down pre-sale yet, but the state of knowledge, practices of refilling those cylinders which prevail in the sector. And they say again, 46, it's for the referring court to assess, but we're going to give some guidance. Thus, it should be noted in the first place that the extent of the information appearing on the new labels is of significant importance. That information presented on the new label must not give the impression that there's an economic connection between the reseller who refilled the cylinder and proprietor of the original trademark. In order to assess the impression, account must be taken of the practices in the sector and whether consumers are accustomed. The nature of the product is obviously going to be relevant. It's a refillable product. There is another factor, it's mentioned in the previous case, which I must have missed, but it is mentioned in Viking, it's also mentioned here, where they say the fact that consumers deal directly with the defendant is relevant as to whether there is likely to be this impression or false impression of commercial connection. In other words, they know who they're dealing with when they deal directly. That is in the Viking case, and let me just find that paragraph of the note. Because this was the counterfactual, this case. Because, as they say in 50, in the present case, it is apparent from the order of reference, neither the proprietors of the original trademarks nor the reseller offer their carbon dioxide cylinders directly to consumers, since those cylinders are available for sale only in the distributors' shops. The absence of direct contact with the reseller may give rise to a likelihood of confusion in the minds of consumers.
Your submission is that this is something completely different to likelihood of confusion, but the court seems to equate the two.
Yeah, I mean, I think it'd be interesting to see how that was translated. But
Are you suggesting that this is an artifact of translation?
No. What I'm suggesting is that they're not actually dealing with the test here. What they're dealing with is the direct contact issue. So this is,
May give rise to a likely confusion in the minds of consumers as to the relationship between that seller and the proprietors of the original trademark. So, in those circumstances, they're saying there's legitimate reasons to oppose.
Yeah. I think I'm more concerned about whether that is a genuine and properly substantiated finding than about the precise terminology. Because it is, as I made the submission a moment ago, a false impression. In answer to my Lord Justice Birss's question, it did occur to me that it's quite difficult to distinguish between a likelihood, or rather to distinguish between confusion as to origin and a false impression as to origin. So I understand that. It follows from the case law that the fact that the original mark of the cylinder remains visible And the additional labelling affixed by the reseller constitutes a relevant factor in that it seems to rule out that the labelling changed the condition of the cylinders by masking their origin. So, direct contact with the reseller, the existence of the original mark on the goods, those are factors that point away from, because one has to bear in mind, these are genuine goods of the proprietor. They're bearing the mark and the rights are exhausted. There is an inherent propensity for people to assume a connection by that fact alone, by the fact that there are two marks on the goods as required. So one
It's not quite as simple as that, though, Mr. Marlich, is it? I mean, I'm not saying they're not genuine goods, by the way. What this case is about is goods which are in a condition which you have won on. You've won on this point, and that's not under appeal, and that's fine. But it's not. They're not identical to the way that they were sold by AGA in the first place.
No,
they're not.
No.
And you're not selling goods like that.
In fact,
and that's okay. It's all okay.
We pray that in A.
Of course you do, but you have to. You also have to accept it. And it's not the same as these facts.
No, it's not the same as these facts. But what I'm trying to say, I'm trying to make a broader point, which is that in all of these cases, and indeed in the judge's findings, which we'll come to in a moment, one has to be careful of being seduced into a finding of commercial connection by virtue of the power of the original trademark being on the goods, because it's got to be on the goods. If you masked the AGA name, you'd be in the Mitsubishi case territory, and you would be infringing, because the non-use of their mark would be potentially a problem. And equally, if you mask your own name for converted goods, that's a problem as well, because they don't want to be responsible for your electrical unit. So use of marks is a really good thing, and is promoted in all the cases. I've shown you the Bristol-Myers Squibb case up to this case. Use of a mark, both sides' marks, is really important. If that's so, one has to be careful of saying, well, those two marks are used together, therefore there's a
Yes, but it's the oldest trick in the book, Mr. Malnich, to say, well, the use of the mark is very important. I mean, what this sounds to me like is all the sherry cases and the champagne cases, all those cases, where the people selling the, I'm going to use the word fake as a shorthand, I know it's not the right answer, non-protected goods would get very holier than thou about the fact that they were required to stick the word sherry on the label. It's just that what they weren't actually required to do is to stick the word sherry in letters 10 feet tall in big shiny things. It's never as simple as that.
It's never as simple as that. But one thing we also know from the BMW case is there's nothing wrong with benefiting from the allure and prestige of the trademark proprietor's goods in relation to trademark proprietor's mark in relation to its exhaustive
As long as you don't give the impression of a connection.
As long as you don't give the impression of a connection. And human nature being what it is, they see two marks together on something, co-branding as it's put by the respondent, then, I mean, if they see a website selling exhausted goods, whatever they may be, second-hand cars or watches or whatever, they may well consider that the website is affiliated with Rolex or whoever it may be, because the two marks are being used together. They're not, you go to the Rolex website and there's not going to be Patek Philippe or whatever it is. So it's human nature, and one has to guard against that easy result. But obviously it depends on the facts. It depends on the facts of the overall transaction. So I think that's that takes me to the end of the sort of legal principles. Oh yes, if I could just ask you to turn back very briefly to 40 of Viking Gas, which is tab 12. That's the point about where both traders did deal with the general public. Of paragraph 40, yeah.
We did look at this earlier.
I'm not sure if we got to the end.
It's the last bit of the paragraph.
Yeah, just the last.
What you're talking about. I think in fairness to you, you didn't actually read out last time. I suspect we all read it.
Great, great. So, I mean, that's a point that arises in this case. Very much. The contact.
Sorry, which paragraph do you want?
Paragraph 40 of Viking,
Okay.
and it's the last bit. But I think we were talking. We dwelled on the false impression, but in fact, it was necessary to go a little bit further. So, if I could ask you then to take the judgment, which you'll find in the core bundle. Tab 9. Although it's a fairly judgment, it's actually the part that concerns us is actually very few pages. After reciting the marks, the relevant legal provisions, the judge comes to the exhaustion defence in paragraph 18, and in particular legitimate reasons to oppose further dealings. Now, it's fair to say that the judge cites the correct test in 22 so far as it goes. I need to show you what he says about that later, but at the moment 22 says, and cites case law we've just looked at, that one of the ways in which legitimate reasons may be triggered is where it gives the impression that there's a commercial connection between the person responsible for those dealings and the trademark proprietor, and in particular the impression that that person's business is somehow affiliated to the trademark proprietor, or there is a special relationship. That is listed with this reputation, damage to reputation, and the impairing of the goods as possible harms under the provision. Now, he then goes on to say that the test under section 12.2 is not whether the further dealings involve such a change of condition or serious damage to reputation or give a false impression, but it's whether the facts taken as a whole, the proprietor has legitimate reasons to oppose the further dealings. So he generalises from those as being examples and says that the overall test is that, which is, I mean, we're not quite sure what to make of that. We don't necessarily impugn that, simply a bit tautological, because it's the statutory language, but and doesn't elucidate matters very much. But it isn't incorrect by being general. Now, he then goes on to say that the court must strike a fair balance between protecting the trademark proprietor's interest in a trademark that has been applied to goods and protecting the interests of others, such as the original purchaser and others who deal with the goods in the aftermarket. Now, I'm going to say this.
Sorry, you've just, I think, crossed
20
over a passage that may be relevant to
Yes.
an earlier discussion.
At the end of 23.
Yes.
Yeah.
Further, the mere fact that customers may be led to believe that there's such a connection, the likelihood of confusion, will not necessarily satisfy that test. If it did, yes, that's a bit of a puzzle as well. What the judge is saying there is that if you've established a likelihood of confusion, not in a double identity case, but in a likelihood of confusion case, then on one view the defence would never apply because you've already established a likelihood of confusion. But I think that is actually talking about different things. You've established a likelihood of confusion between the trademark and the use on the goods.
So you accept that he might have made an error there, but if he did, it's an error in your favour.
Yeah, it's not really material to the outcome. The The next point is that he says the court must strike a fair balance, but what we say about that fair balance is, well, we say that's the last we hear of it. He never actually strikes the balance. He says the court must do that, but he does not weigh any of the factors that you must put into the balance. For example, even as the gas cases did, the rights of consumers to refill, the competition in the market, what the traders are up to. He didn't look at what...
This may be me being confused, but in a sense, hasn't the balance been struck by the Court of Justice telling us that the creation of an impression is sufficient? And I understood your submissions that in working out whether an impression was created, you have to take all relevant factors into account. But isn't that the end of it? Where else do you strike a balance, given that the Court of Justice tells us that the creation of an impression is the legitimate reason?
There's 2 points I would make in response. The first of them is proportionality becomes the receptacle for deciding whether this should trigger legitimate reasons to oppose. So the second answer
Sorry,
is...
where in the case law that we've just been through was there reference to proportionality?
Not in express terms, but that's a general principle of at least EU law. But the second basis, which may be a bit more familiar in terms of my submissions so far, is this is another indication that of standard of seriousness. I don't want to use the word serious. The conviction in which it has been made out, the conviction that one holds that there is a genuine and properly substantiated false impression.
Yeah, but as my lord said, in this jurisdiction at least, facts are proved on a balance of probabilities. So I'm, for myself, struggling a bit with the conviction point.
It's also, yeah, I mean, there is actually 2 separate concepts. It's the degree of conviction you have in the outcome, but also the scale of the problem. The scale of the problem being the degree of seriousness of the, let's call it confusion or false impression. So if, for example, there is a very strong public interest and a very flourishing competitive trade in that sector, and what is being complained about is a fairly trivial level of possibility of connection between the businesses, one may take the view that is not put them all into the mix. But actually the other thing, as we say in our skeleton, is that this balance actually comes in at an earlier stage. It comes in at the stage of exhaustion, if one looks at Viking, which is a rather strange time for it to come into the analysis.
I mean, Mr. Marge, isn't it? Well, what strikes me is that the cases you've taken us through show that this legislation is there in order to strike a balance.
The legislation itself.
Yes, the legislation, exactly.
Yeah.
What I don't think the cases have ever said is that, and I can understand why, therefore, a judge starts referring to striking a balance in the context of analysing the law.
Yeah.
But I don't believe it's right, but you tell me if I've got this wrong, that the decisions you've shown us show that it's a job for the trial court to approach the task as being striking a balance. What the trial judge is there to do is apply the law and make the finding of fact, in this case, about impression of trade connection. Yeah. Is that fair?
The fact that I struggle to answer the ladyship's question, I think, shows that may well be fair. The point is that the confusion starts because in the Viking gas case, they talk about this happening at the stage of exhaustion. But exhaustion would seem to be simply a yes or no answer. Did you consent to putting the goods on the market or not? So you're not really considering anything multifactorial at that stage. So maybe that is the answer to the question, which is it is these interests that are protected in the legislation. And that is fine because, of course, we say that one way or another, it's still necessary to take into account the various things that the case law says you should take into account, whether they be characterised as part of the interests of consumers or the interests of the trade. Doesn't matter. It's a matter of what information you need to reach the right conclusion. Now, judge acknowledges that he didn't find this an easy matter to decide, and one can well see that. But he decides that the claimant does have legitimate reasons to object, and he says that's not because of the extent of the works that the defendants did on the cookers, or because of the fitting of the e-control system, and nor is it because there's a serious risk that there's been damage to the image of the marks, but rather it's because of the way in which the defendants marketed and sold the e-control cookers. It then goes into the analysis of the work that was done on the test purchase.
Just pausing there at that summary, because it's obviously a summary of what he's then going to explain. Do you accept, would you say that that is not stated at that level of generality, that's possible? It's open to a court to reach a conclusion like that?
It's open to a court to reach a conclusion, yes. But
I understand you say that he got it wrong in doing that. I understand.
Well, no. There's a legal way station before he then gets it wrong on the way he did it, and I'll show you that.
Okay.
So the next stage is he considers the specifics of the allegation. And just to give you a flavour of the trial, I mean, this case was put from the outset on the basis of impairing the quality and functionality, even safety of the goods. I don't know if you've looked at the pleadings, but the website that the judge held was led to a commercial connection, was actually in the particulars of claim, was annexed to the particulars of claim, and nothing was said about that website being, that stage, nothing was said about that website being a misrepresentation or containing any problems. The reason why it was in at all was because the claimant was putting its case on the basis these are not Argas at all. So your reference to them as Argas is a trademark infringement. It wasn't put on the basis that these are exhausted goods, but you're nonetheless professing a commercial connection that doesn't exist. That came later, and I think it's true that it came for the first time in the trial skeleton. This whole issue was very much an afterthought. You can see from the analysis of the technical part of the case. Now, I'm going to pick it up then at 35. This is one of many paragraphs where the judge acknowledged that there was a reasonably extensive market in the sale of second-hand refurbished Arga cookers. Now, he notes that my learned friend was critical of my client's evidence on this issue. 55 companies were listed as offering a business or trade in second-hand cookers.
But how many of those 55 offered electronic control systems? Or electronic conversion kits?
I can't recall. I may remember from his first information. I can't.
Well, would you accept that there's a difference in kind between simply selling a refurbished Arga cooker on the one hand and selling a refurbished Arga cooker with an electrical system in place of solid fuel?
Yes, I would accept that, but refurbishment is common to both of them.
There may be, yes.
They're all second-hand.
But you could sell the electrical system for a relatively new solid fuel Arga.
Well,
or indeed to convert a gas one.
It's going to be second-hand. The business lines. The lines of business my client were sale of Argas with the electric kit installed, sale of the electric kit alone, and installation of the electric kit on your premises. The claimant complained of A and C, but not B. So there is a
But
difference.
the reason for my question, as I'm sure you appreciate, is you rely on saying, well, there's 55 companies in this field.
Yeah.
But if they're not selling electrical kits, why are they in the field?
Because they are part of the second-hand market. And this is part of the second-hand market too. My client is not the only electric conversion operator. And this is obviously, let's say, this is the trajectory of AGAs nowadays. I mean, this is the way they are going because we don't want to leave them on all the time, burning energy, and conversion is a major thing. Now, of course, AGA do not sell second-hand.
Can you point us to a finding in the judgment that there is any other company in the market at all, apart from yours, selling these electrical kits?
I think there's mention of electric kit. Which is
Right, so
the
one
only
other.
evidence. No, there's many. There's many. You mean selling the e-control kit? There's many sellers of the e-control kit.
No, that comes from you.
Yeah.
So the question is, are there any other suppliers of electrical systems?
The electric kit. There's at least one. I don't want to give evidence more, but there's certainly evidence of that.
Well, first of all, where do we find that in the judgment? Secondly, if it's not in the judgment, where is it in the evidence?
Can I show you that? Because I've got third-party material to show you in a moment. What I would just say is this, my lord. I'm a little bit reluctant to accept that somehow the second-hand refurbishing market is irrelevant to the customs of the trade. I mean, obviously, the other electric kit sellers and our distributors and the way they market their goods, that's relevant too, probably more relevant. But the critical part, and I'm going to be submitting in a moment, so I want to make this very clear. AGA don't sell second-hand goods. They sell electric AGAs, but they're new. My client's entire business model, as anybody knows, is on used, exhausted AGAs. And that's the same with the refurbishing, and it's the same with conversion to gas, conversion to any other fuel. So all of those activities take place in the secondary market, the aftermarket. And to that extent, they are relevant, and the judge acknowledges that there is not only a flourishing aftermarket, but that consumers have a reasonably high awareness of it. You may recall that later in the judgment, when dealing with the appearance of the cookers themselves that have my client's mark and the AGA mark on the front, that consumers, the judge finds that consumers would expect there to be some work done or conversion done or parts added with these second-hand goods. And so they're out there, they're relevant, and consumers know about them. Now, what this paragraph is talking about is there was in fact some that were providing the service of installation rather than the sale of cookers.
Like the service of refurbishment.
The service of refurbishment, yes. We say that's relevant as well. This is all part of a group of services that are to be considered together. It's a bit like Mr. Deenick, whose activities of repair and activities of second-hand goods were pretty much treated as the same thing. They're services and goods which depend upon a secondary market, and that's certainly the case with these traders. Now, then there's reference to the Which.co article. Can you buy a second-hand AGA? Yes, given the longevity of AGA cookers and the cost, there's an active second-hand market. Shopping around, it's possible to get a second-hand that's been renovated to look like new, but comes at a much cheaper price. Not that much cheaper. Still talking 5,000, 6,000, 8,000. It's still not very accessible to ordinary members of the public. So he just goes on to find that the mere fact that the works were done didn't give the claimant legitimate reasons, and of the conversion works, he finds the same thing in 40. As with the renovation works, it doesn't seem to me that the conversion works per se gave the claimant legitimate reasons to object. He then deals with the reputation claim at 41, and that is also not made out. See 46. And then there is, are there legitimate reasons based on the way in which the defendants marketed and sold the e-control cookers, and are there, does this give legitimate reasons? Now, I mentioned to Lord Justice Birss that there was a legal way station. That is in 48. So he starts out by saying, I turn then to the
Before you get to 48, would you accept that the test posed in 47 is correct?
Yes. Some commercial connection. It's not necessarily, it's a little
The
inaccurate.
impression that there was some commercial
Yes,
connection.
some commercial connection. Well, it depends what that commercial connection is. I don't think they use the word some commercial connection. They say a connection, but it's broadly
Sorry,
correct.
is your submission that the word some is legally erroneous?
Because it could import any kind of, that's why, any kind of commercial connection. But I mean,
What kind of commercial connection could there be that would be not relevant?
Well, the relevance of the commercial connection.
Well, relevant
is
in
important
your,
in the case.
I'm trying to put back to you what you've just said. Your submission is that the word some allows it to be possible, as I understand it, that there would be an impression of a certain type of commercial connection which doesn't amount to a legitimate reason to oppose, and I'm asking you to give me an example.
I mean, it could be customer versus seller, some sort of commercial connection. I mean, it depends. Linked undertakings.
Sorry, he says commercial connection between the defendants or their products and the claimant.
Yes.
So he's not talking about connections with third parties.
No, but it could be talking about. It's just look. I think for an easy life, I will accept my law's formulation. I don't want to resist. I don't want to resist the unpopular. But I think the thing is, it's not exactly the formulation adopted, but it is good enough. It's good enough. But the key point is that in the very first line of the next paragraph, he imposes a further criterion, which is how you establish that there is the requisite commercial connection. And that is the keyword test from Porter Cabin, and that is conditions his approach. And my learned friend is going to say, no, he reached findings of great conviction if you look at his factual findings, but we cannot know that with certainty when the judge has specifically held that in order to establish the requisite commercial connection, X, Y, Z needs to be made out.
Well, can I ask you this question? It's because it goes back to paragraph 40 of Viking, which the judge cites, because in paragraph 40, the Court of Justice does indeed speak about must not lead the average consumer who's reasonably well informed, reasonably observant circumstances, consider there is a connection between the two undertakings at issue in the main proceedings, or the gas is used to refill those bottles. Of course, that bit is case specific. So,
But considers that there is, it's very much not case specific. From 40 of Viking. And that's the test. It's the false impression, considers that there is. What it isn't is this, I apologise, I interrupted my lord, but I hope that's the question you're asking me. But what it isn't is the difficulty in telling test that the judge goes on to explain in that paragraph.
okay.
Now, he then applies that. If this case was simply about defendants selling refurbished second-hand Arnold cookers, then in my judgment, it's unlikely that a customer or potential customer would have gained the impression that this was an activity connected with the claimant. I pause there and I rely on that. My client was selling refurbished cookers. with a kit. Now, to the extent that I know that there's a difference between those two things, but they're not different in one respect. AGA don't do either. That's the key point. So if you are going to say that the website, which we'll look at, linked my client at AGA, then you have to overcome that consumer prejudice, which the judge himself has identified. It's unlikely that a customer or potential customer would have gained the impression that this was an activity connected with the claimant. Well, that's our fortiori in relation to refurbishment plus conversion. It would be directly competing with AGA's own ER7 product, which is sold as new electrical. I think that was the current product.
Mr. Marlish, you link 49 to something to do with consumers' knowledge about what AGA does or doesn't do, but I don't find that anywhere in 49. That that's got anything to do with what the judge is saying in 49. It doesn't strike me. I'd like, if it is your case, I'll need some help. That para 49 is a finding that has some relationship with the point that you've made a number of times that AGA don't sell second-hand AGAs.
Sorry, my lord, you're asking me whether I'm pushing that too far.
Well, no. I mean, you draw attention to this and you say you rely on it. I get that. But then you said it was. Then what I thought you said, and I may have misunderstood it. In which case, please tell me and I'll stop. that you were saying that this point that you're relying on had some relationship to the point you've made a number of times that AGA do not sell second-hand AGAs.
Yeah.
But I don't find anything in 49 that seems to connect to the fact
I see, yes.
that AGA don't sell second-hand.
You're right. I'm reading that into it because why is it that a customer or potential customer would have gained the impression this was an activity connected with the claimant? So I'm filling in the blank there. I think that's what my lawyer is asking me. That it does not say why consumers would be unlikely to connect.
Yes.
My lord's right.
So you're effectively saying that we need to make an assumption that one of the attributes of this consumer who may or may not gain an impression is that they know that AGA don't sell second-hand AGAs?
Yes. Yes, and in fact,
Really?
the judge identified the average consumer in this case at quite a high level of knowledge and care. That they were defined as a consumer who has is interested in buying an AGA or owns an AGA and wants it converted or refurbished, and so that's going to be in that group of people. Of course, there will be.
Sorry, but the judge didn't make the finding that I've just.
I was just looking for the paragraph. I'm not sure how much knowledge he said he gave them about AGA. So, you find the average consumer paragraph. Is it 70?
See, what you're positing is a finding of a negative. I mean, it's one thing to make a finding as to what consumers do know, or are probably likely to know.
Yeah.
It's another thing to say, here is something that consumers don't know.
Yes. They're defined as someone who's already owns an oil or gas AGA cooker and who's interested in electric conversion or is considering purchasing one. Given the relatively high prices, I think that such a person would display a reasonably high degree of attention.
Which paragraph is this?
Sorry, 17. This was common ground. It's an ordinary member of the public.
Yeah, sorry, I was just misspeaking the question I was asking, and I apologise.
No,
Let me articulate what I was trying to say and completely mangled. It's one thing to say what a consumer understands that AGA do. It's another thing to posit that consumers understand things about what AGA do not do.
The judge found there to be a flourishing trade in used second-hand AGAs.
To be sure, but how does the average consumer know from that AGA don't do it?
They're the original equipment manufacturer. not.
Well,
Well, there may be people who don't know that.
I can see why you're making this submission, because the logical consequence of it is there can be no impression of a link, because Argo dust don't get involved in that sort of thing. But that's nowhere near what the judge has found.
Well, the judge has found, I think we need to look at the paragraphs where he is discussing the average consumer's understanding, and he does find that there's this flourishing trade. If the consumer is aware of the flourishing trade and they don't see Argo doing it, then
Does the judge say flourishing, by the way? You said flourishing a number of times. And I don't
it's
remember
probably my paraphrasing in my notes.
Which paragraph is it that you're relying on?
Let me just.
There's a reference to it in 49, but it must come earlier as well.
Yes, it does.
Active market.
Active market. Yes.
Yeah, reasonably extensive market, he says in 35.
Yeah.
The other way of thinking about it is 49. Why would the judge, and this is why I rely on that, why would the judge make a finding and ask for it actually as to that consumers would not have gained the impression of that being an activity connected with the claimant in the case of refurbishment? If they don't know, or at least have the impression, that's not something that I would do. Because that's a general statement about consumer perception. He's ruling out all cases, effectively. It's unlikely. And I read that as being because they would know that second-hand... See, it goes on, actually. A customer buying a second-hand cooker would understand that it may well have been refurbished and would have no particular reason to think the claimant was in any way linked to either the refurbishment or the resale. So they don't necessarily, back to my Lord's question, it's not necessarily things that they don't know. They're not sure, but that is not likely to lead them to confuse the two. In fact, it's a factor that points away. It's a factor that points away. And that's important because, my lady's absolutely right, we do rely on that as being an important factor relating to context, what the consumer, which has been defined by Justice Kitchen as he then was, as all of the circumstances that operate on the mind of the consumer in an ordinary trademark case. And all of the circumstances that operate on the mind must, in my submission, include they have never seen Argo selling second-hand goods. They have seen a plethora of other traders. They are taken to be interested in acquiring a second-hand or refurbishing or already owning one. This is a somewhat niche market, not least because of the price. And my submission, that's a reasonable point to make. There are other mentions of it. I may have to come back to it. So he goes on to say, what makes the present case different is the way in which the defendants went about marketing and selling the e-control cookers. Cookers which are not only refurbished, but also fitted, so he does acknowledge refurbishment, but is also fitted with the e-control system. In this regard, the claimant points to the defendant's website as it existed in October 2022. Now,
So just getting to before the website, one might want to say that if you read 49 and the first sentence of 50 together, you can see that the distinction the judge is drawing is nothing to do with what AGA do. It's about what your clients do. They sell either, if it was just refurbished, that would be one thing, but what's different is the way the judge is drafting the judgment is because it's refurbished and it's e-control.
and what I would say about that, which should raise an immediate red flag for the court, is the judge is indicating this sphere of activity is itself potentially problematic.
He says it's what makes the case different.
Yes, but it's interesting that the distinction that he draws from the outset is look at this trade, which is different. Now, this trade is extending the life of goods that could end up on the scrap heap. It's allowing greener energy. It's allowing more accessibility to very expensive products. and all other things besides. And therefore, to say that because it's not pure refurbishing, it's another valuable aftermarket service in my submission, that's itself a
That would
problem.
be contrary to his finding. There was nothing wrong with what your clients were doing in terms of fitting and selling the e-control system.
Correct.
So the problem is not the fitting and selling of the e-control system. The problem is the marketing.
How it is presented.
Exactly.
So it cannot be the nature of the services that is causing the problem. It cannot be. Oh, it should not be.
No, but that's what the judge is doing.
Now, we say that if you approach the website with that principle in mind, then it is impossible to understand how the website was in any way objectionable. Just ask you to take a core bundle. No, it's the supplemental, sorry. It is tab 13. Yes, tab 13. Now, bear in mind that the judge's finding here was not that this presented e-control systems as an affiliate of AGA, but that this was AGA. This was AGA. We know that because e-control was said to be a model name, a sub-brand of AGA. Now, my submission, if that can be said about this presentation, then it can be said about anybody that uses their trademark in the aftermarket to sell goods and depict those goods in photographs where those goods are exhausted AGA goods. Now, can I just make a couple of submissions on this? First of all, it says, I mean, one struggles to find the statement that was objectionable by the judge by an e-control AGA in a little label there, in a little white label, when it is quite clear throughout that the e-control system is the name of the relevant unit. E-control cookers is the name on the domain name, and e-control cookers is also clearly the name of the business at the top of the website. Furthermore, just on this page, the judge seemed to regard the picture of the AGA cooker with the...
Can you help me on this? Of course, what we've got here in the usual way, and I'm not blaming anybody at all, it's what one has to do, is a printout from the website. And as printed out, we've got the date and the time, and then we've got a heading, Electric AGA Sales UK, then e-control systems, then e-control cookers, which suggests that there is, well, let me ask the question.
I'm sure I won't
The expression Electric AGA Sales UK, what is that representing?
I don't know, Lord. It could be embedded text, possibly invisible text. I don't want to give evidence on it, but I don't know is the answer to that. The judge didn't refer to it, and so I'm assuming it was not, he assumed it wasn't part of his analysis.
Well, one would assume that it's something that represents the organisation of the web page.
Yes, it might do, or it could be meta tag, although I'm not sure they look like that meta tags today.
You wouldn't get a meta tag
No.
in a printout like that.
No. So it's part of the header or footer, but not necessarily exposed to the consumer when they look at this, unless they print out. The point I wish to make about this is that the information on the front page as to what this is that With decades of AGA expertise and conversions, we've been carefully listening to our loyal customers who wanted a reliable yet more up-to-date conversion than the traditionally utilised 13-amp systems. So we know right away that there is a conversion system called the e-control system, which is being offered. Now, there are pages to this, and my lord, the learned judge, said he looked at it as a whole, but every page makes it clear that this is talking about a specific unit that is applied in the aftermarket. It specifically refers over the page to a retrofit conversion system that has modern life in mind. And it is regularly called the e-control system. I mean, that's the name of the product. All of our e-control cookers, I mean, one struggles to find the mentions that the judge picked up on. They are there. I'm not saying that they're inaccurate, but they are not, in my submission, anywhere near significant enough for this to be converted into...
I understand the submission as to what the meaning of the statements is, but in terms of prominence, which seems to be what you've just said, when we look at paragraph 50, he recites basically all the relevant words that are on the front page.
Yes.
So he's not taken something that's obscure, has he?
No. Well, obscure, I would say, compared to the e-control system, that the little white box...
Sorry, he sets out those words. He quotes those words.
Yes, but of equal size to buy an e-control AGA, which is like microscopic below that in the white box. I mean, you can
So the judge's offence is that he's represented them in same size font. Is that it?
My lord, no, there's no offence to that. Even if those had been in big font, they were still not in any way indicating a commercial connection.
Mr. Malik, can I just ask you a different question that relates to this? As I read these words, whether it's in the judgment or on the website, I ask myself the question, who's we?
Who's we? Yeah.
Because in all this text, the only signs, to try and use a neutral term, are e-control or e-control system and AGA.
Yeah.
But e-control is a system; it's not a we. So the only other entity that could be we is AGA.
No, e-control cookers.
Where does it say that?
That's the top of the website. That's the bottom of the website. It's a domain name.
Why are they not cookers?
Yeah, I mean they are a.
We're just looking at those that text.
Yeah, absolutely. I mean,
with decades of AGA experience, e-control system.
Well, decades of. Why even seasoned AGA lovers are flipping the switch? That's competitive language.
Well, I understand that's a critical. It sounds like it's a critical part of your case, that you're positing that the average consumer knows that AGA don't do this. And I can understand that if you know that AGA don't do this, then you read this in a rather different way. But the judge doesn't approach it on that basis. He didn't make a finding like that, as far as I can see. You say you should have done. I understand that. Yeah. But on the basis of the way the judge is looking at it, he's not saying I'm reading this as if I don't know.
If you don't know, my lord, you still do not take the language on that page as indicating that the we are AGA. And the reason for that, I mean, we have to approach these things with a real world view. Why even seasoned AGA lovers are flipping the switch is this is competitive to AGA, and with decades of, AGA do not boast about having AGA experience of decades and conversions. They just don't. Why do they do that? They are AGA. It's someone who is worked on.
Why isn't the we an affiliate of AGA? Someone dealing with AGA goods, which is what the judge has found. What he's found is that an e-control AGA sounds like a range of AGA products.
Yes.
That's the finding against you.
And that itself is also bizarre because it does not follow the formula of any AGA mark. AGA marks are the word AGA followed by numeral whatever. They're not something.
Is there a finding of fact that consumers approach the AGA mark in that way?
Well,
I don't
the
think
judge
it is.
himself gives examples of
Well,
the...
that's a different point, Mr. Marley. Did he find that the average consumer is so sophisticated in their knowledge of the AGA mark that detail you just explained was part of their thinking?
Well, the average consumer in this case was spending or about to spend £5,000, £8,000 on a reconditioned product and was effectively an AGA aficionado imputed with a reasonably high level of attention by the judge, common ground between the parties. That person is not going to be responding to these statements in an unmediated way. It's going to be an understanding of when they say decades of AGA experience, that means that they've probably worked on AGAs. They've got people that work in the company that collectively have X number of AGA years experience working on AGAs. But if you then look at every page, why would AGA be, and this is part of my case as you rightly say, why would AGA be retrofitting their own product competitive with their own electric product? I mean, again, yes, I do impute on the consumer that they are reasonably familiar with the AGA range of products, prices, what they are doing, because the judge identified that consumer. Now, the we throughout this document is referring to e-control cookers, and e-control cookers being the name of the company or the name of the undertaking. The system is the product, and the judge's objection appears to have been because of the placement on the front page within that white box of by an e-control AGA. That is an entirely conventional way of referring to your own refurbished, resold products. Our products, our AGAs, I'll show you that. You can see that in the refurbished trade, you see that in the distributors that sell our products, and they aren't sort of made to do it in the same way, and they don't. They come up with a plethora of ways, all of which are very similar, though, in one material respect.
Can I just try and pick up where we find the bits that the judge has referred to? Because we see what he refers to in paragraph 50, most of it is on the first page, the printout 156 in the bundle. Then we've got various bits of printout that he doesn't mention, including at the bottom of 160, we see the AGA traditional versus controllable, which the judge doesn't mention. And then the next thing he mentions, I think, is 161, where he refers to the line drawing of the AGA cooker with the caption "controllable AGA cookers."
Yep.
And then he says, followed by a page showing numerous possible AGA colours.
Yes.
And I wasn't quite sure where that is. Can you help us
further
with
on,
that?
it comes as quite a long document, this, but it comes, yes.
Well, because it's always the problem, because when you print out a web page, it often prints out as several pages.
176
176, yes.
Thank you.
is the colours. Did the judge not have the full document?
Well, he referred to the AGA colours, so I think
I know, but
he didn't refer to
says
some of the other pages.
on the next page, it's not on our next.
Yeah, I think he did. I don't know.
Okay.
So, I mean, what I will submit is our AGAs, the AGA, traditional versus controllable, mention of AGA. That is what exhausted rights are all about. These are AGAs, and it is entirely customary for people in this trade, and I'll show you examples, to do exactly that. They use their mark, as they should, in relation to exhausted goods. They should indicate their own identity, and they must use the AGA mark. And if they get a benefit because of the well-known nature of that mark, there's nothing intrinsically wrong with that. And it cannot be, my lord, lady, that in a case like this, where you have an entirely conventional way of presenting a useful and competitive aftermarket service, where you do not say we are AGA. I mean, what's significant is you don't see anything that says that we are AGA, that we're affiliated to AGA, anything of that nature. These are, at best, implicit statements or implicit understandings, which are just, they don't sit with an assessment of the practices and norms of the trade. If it's allowed in this case, then many other traders that I will show you should have difficulty sleeping, because they've done exactly the same thing. Now let me show you, first of all, the other electrical. First of all, let me address one or two of these points. First of all, so far as the line drawing is concerned, you'll recall that, of course, no objection was taken to the appearance of these goods themselves as indicating a commercial connection, other than in the post-sale world. So it was not said that when we sold them, and they looked like the photograph that you see on the front page, it was not said, oh, that's an infringement, that's a commercial connection. I don't know why, but it wasn't. And then you've got that allegation was made in the context of post-sale confusion and failed. And it's interesting to see the judge's analysis of that. He basically says consumers won't be confused, even though you've got these two brands on the front, because they know that with goods, second-hand goods like this, they're likely to have had some work on them, and the person who did the work is likely to all want to put their brand on. Well, that applies exactly to the photograph that the judge seemed to think was a problem on the front page. It is exactly the same appearance. In relation to the colours, evidence was at trial that that is standard. But when you refurbish, it's very often the case you re-enamel, because that's one of the things that does degrade. And of course, people often want the classic darker colours. They sometimes want different colours as well. But there is nothing about proprietary in that. And indeed, if you're selling goods in which it's exhausted, making those goods look as faithful as the originals tend to be something that proprietors should be encouraging, as not undermining the condition of the goods. But I would urge, my lords, to look at the text of these, because the average consumer is someone who's interested in this service and will read these things. And you also have to consider not just this website, but this website in the context of the transaction as a whole. As we know, it's a whole transaction approach. All of the activities.
Right, and so therefore the judge was right to consider the invoices as well.
The judge could consider the invoices. I've got no fear of the invoices, my lord, because the invoices could not possibly have the effect intended for, not only because of the stage at which they are introduced into the picture, but because they are just, they're not promotional documents in any way. If I go and get my car serviced at a mechanic's garage and I get an invoice that says fit new exhaust Toyota, doesn't mean they're linked to Toyota, because they put that in the rather elliptical language used on an invoice. And that's all that's happened. In fact, if you look at the invoices, if we just have a look at those are next. Those invoices are a very mixed bag. There seems to be a number of ways.
So the first one is at 177, is that right?
Yes, well, sorry, I should have given you a page number. It's, there's a few patterns here, but we would say of these invoices.
So here, you made the point about the e-control AGA being the wrong way round. Of
AGA
course,
e-control.
here it's the right way round. AGA
Exactly.
e-control.
Exactly, and that's the reason for that is because it's almost random the way that this can be put. If you look at the next one, it's the same. You've got
And then it says £7,500 for supply and fit of AGA in white, inclusive of VAT.
yes, and then you've got another one the judge picked up on 184, deposit re AGA 100. Lord, how is it possible that using a mark like e-control, which the judge said was distinctive, puts you in greater difficulty than having no mark alongside AGA? Because that's what everybody else does. They don't put anything next, or most people don't put their own mark next to it.
I'm sorry, you said the judge picked up on this one in particular, but I can't find it mentioned in paragraph 53.
Is the one, there were a number with numbers, maybe I've got the wrong one.
What would be very helpful, not necessarily right now, would be to give us, if you could give us a list of page references for where
Yes.
all the various things at the end of 53 come.
You mean for the invoices specifically?
Well, yes, and for that matter, any other references, quite honestly, but in particular those invoice pages.
I think, so...
You don't have to do it now, Mr. Malinich.
I'm grateful. The AGA 100 is mentioned at the end of 53. So, I mean, that's one of the kinds. But what you see from these invoices is some have e-control after, some have e-control before, some don't have e-control, some just have AGA, and AGA 100. Some say, for of an AGA for e-control kit.
Right, so that seems to be an indication that the judge's finding in the last sentence of 53 is entirely accurate in terms of what's there on the invoices.
Yes, but what is the irrationality of it is it is not explained how that creates a false impression, even on its own merit.
Isn't it explained in paragraph 52 at the top of the page, if you've got it paginated, where the judge, at least struck me this was an important finding, in the way the judge's judgment was constructed, where it says at the top of page 119, in this regard, the reference to the, quotes, e-control AGA, end quotes, was likely to be seen not as descriptive, or not as purely descriptive, but rather as part of the brand of the product being offered for sale, just as ER and so on, and as linked to the AGA name, which is a highly distinctive character. Isn't that the point the judge is making? He's saying what's happened here is that your clients have created this new composite thing called an e-control AGA, which is as if it is an AGA product, and it's not an AGA product.
Yeah.
That's the impression that's the core of what's creating the impression that the judge is finding that you shouldn't be doing.
One of the things one has to be very careful of is approaching this as if it's just a likelihood of confusion case when you're dealing with indirect confusion. Because in this case, you have to use your own mark to indicate your own.
You do, but you don't have to put your own mark and the other mark together in that composite fashion.
The cases show that you should, and do on pharmaceuticals, and you do on
No.
Not necessarily.
No, that's not right.
Well,
Paranova and Co. is not about saying that if you're selling, I'm going to make up a drug name, I can't think of one, aspirin, that when you parallel import it, you call it Malinich aspirin in that sort of composite fashion. You have to write the words Malinich on the box, and you have to write the word aspirin on the box. Nothing about this says that you have to create a new composite mark.
I understand that. What I mean was this. You must use both marks in view on the packaging.
Yes.
And the same with the cylinders and the other cases.
Yes. But you didn't
This
do
is
that.
an invoice.
The point is that what's been put against you,
did
Mr.
do that.
Malinich, is you didn't do that. You didn't only do that.
Well, Lord, in my submission, looking at the website, that is exactly what we did. We put e-control system, e-cookers, e-control, and there's one mention on the front page in a tiny writing in the box, which has it on the front page. The invoices cannot possibly be an indication of the way the goods are marketed. Because it's an invoice, it's a line entry on an invoice.
It tells you the goods are called an e-control AGA. Not the one that says AGA 100, I grant you, but the other one does.
The question is not the naming convention, my lord. The question is whether the consumer thinks at the end of this process we are arguing.
Yes, and what's been put against you, and I'll be frank, I haven't heard an answer to it, Mr. Malovich. What your clients have done is created this composite, which they use. They don't use it all the time. There's examples where it's not on the invoice. It is on the website, and it is on the invoices, and it's that composite the judge draws specific attention to 3 or 4 times. It's obviously what he thinks is very important to this impression. And I understand you repeatedly reply by saying the law requires me to put my brand on it and the other brand, and we agree about that. But nowhere, at least as far as I can see, have you explained to me why the judge is wrong in his conclusion that that composite is something which plays an important role in this.
My lord, we don't use it on the website. It is
Right.
not. It's used once in a box. It is not used as the formula on the website. The website says e-control cookers, e-control this, e-control that. It doesn't say that is not a formula that you find repeatedly through the website. It is simply a stray reference that happens to be in a box. So far as the invoices are concerned, there is no particular pattern. But those are not. I mean, I don't want to repeat myself, but
Yeah,
those
all right. I think we have got the point. Thank you. So we'll pause there. Now, strictly speaking, on the timetable that the parties agreed to kindly supply to the court, we're out of time. But no doubt Mr. Silmy wouldn't protest too much if you had another 5 minutes after lunch.
I'll be enjoying it.
All right, we'll resume at 2 o'clock.
Court rise is able.